Start. In this criminal revision filed before this court, a question has been raised as to the propriety of the court concerned in passing an order for payment of arrears towards maintenance for a sum of rupees 57,000 by the additional principal judge, court number 3, Kanpur, Nagar. Submission advanced is that the arrears that have been directed to be paid to the opposite party number 2 relate to the period starting from the month of March 2021 to September 2022, and since the application for payment thereof came to be filed only on 21/11/2022. It got hit by the subsection 3 of section 125 of CRPC. It is contended that subsection 3 of the section 125 CRPC puts a fetter upon the right to opposite party to recover the maintenance amount beyond period of 1 year, and accordingly, as has been argued, the additional principal judge family court has wrongly construed the relevant provision in passing the order. Learned counsel for the revision applicant has also submitted that the very judgment relied upon by the judge family court helps him out in assailing the order passed by the judge, which very much interprets the provision. Per contra, it is argued by Sri Gupta, learned counsel for the contesting opposite party, that the first application for recovery of an earlier amount came to be filed on 14/12/2020, and since the claim for maintenance amount is a recurring cause of action, therefore, if the applicant husband has failed to pay any amount of maintenance on month-to-month basis, then such cause of action will continue to be rendered is continuing cause of action month by month as such, and will not be hit by section 125 (3) CRPC. Thus, it is argued that the judgment which has been relied upon by the judge family court correctly interprets the law, as it holds that the right to recover the amount as far as regular maintenance is concerned is not hit by section 125 (3) CRPC. Besides the above, it is submitted by Sri Gupta that taking the provisions as have been incorporated by the legislature, the monthly maintenance claim does not become a time-barred claim. All that is to be seen, according to Mr. Gupta, as to what mode of the recovery of amount is to be adopted. He submits that a coercive measure by arresting a person may not be readily available to the opposite party beyond the prescribed period of 1 year, but a right to claim maintenance or arrears of maintenance pursuant thereto in order to claim maintenance month by month does not get adversely affected or prejudiced merely for an application being filed beyond prescribed period of 1 year. Having heard learned counsel for the respective parties and having perused the records, I find that the order of maintenance allowing the application under section 125 CRPC, which was passed on 9/5/2018, very clearly provided that the application under section 124 CRPC was being granted, and rupees 3,000 shall be paid towards the maintenance to the opposite party applicant, as the opposite party was held entitled to a maintenance from her husband. This thus goes unequally that the monthly maintenance was to be paid by the present applicant to the opposite party for rearing up the minor children. However, it transpires further from the record that earlier also some arrears had become due to be paid to the opposite party at the end of the applicant, and accordingly she had moved an application on 14/12/2020 to recover the amount of rupees 24,000, which was subsequently paid to the applicant to the opposite party. However, later on, again, did not pay the amount as far as arrears are concerned, and therefore amount accrued to rupees 27,000 between March 2021 and September 2022. It is for the recovery of this amount that the application came to be moved by the opposite party in October 2022, which was claimed to be beyond prescribed period of time. Section 125 CRPC in an enabling provision insofar as deserted, neglected wife claims maintenance from her husband more so along with her children, and this right vests with parents as well. It is kind of summary proceedings to be instituted at the end of application made by wife or the children or by the parents from a person who is the earning member of the family and is under an obligation to maintain them. After inviting objections and meeting the points of contentions, a magistrate has been empowered to pass orders on merit for maintenance. Of late, this power is transferred vested with the Judge Family Court on the Constitution of Family Court under the Family Courts Act 1984. A court, when passes a decree or order which is continuing in the nature, it is to be seen as to in what manner a fetter of limitation can be imposed for recovery of such amount of maintenance. For ready reference, subsection 3 of section 125 is reproduced hereunder. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any port of such month's allowance for the maintenance or the interim maintenance and expenses of proceedings, as the case may be, remaining unpaid after the execution of the warrant. 2. Imprisonment for a term which may extend to 1 month or until payment of sooner made, provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it become due. Provided further that if such person offers to maintain his wife on condition of her living with him and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section notwithstanding such offer if he is satisfied that there is just ground for so doing. From a bare reading of the main provision as contained under subsection 3 of section 125 CRPC, it is explicit that the magistrate has been vested with the power to issue warrant for remaining of the amount due in the manner provided for levying fines in, and may sentence such person for whole or part of each month's allowance for maintenance, or if for interim maintenance and expenses of proceedings, as the case may be. This is a coercive measure contemplated under subsection 3 of section 125 CRPC. The legislature has been conscious enough to provide for a proviso where a wife may be not vigilant to her rights in recovering the amount in time, and therefore no such coercive measure for issuing warrant of arrest, etc., will be issued. This is what is contemplated in the first proviso to subsection 3 of section 125 CRPC. The courts have been interpreting the provision to mean that such coercive measure should not be adopted where the wife or any claimant under section 125 CRPC has not been pursuing for recovery of arrears for over a year but that does not mean that the right to recover arrears is lost. This could not be the intent of the legislature in incorporating the first proviso. Otherwise, the language of the first proviso could have been couched in a manner that no recovery would be made in respect of arrears beyond the period of 1 year. All that is provided is that no warrant will be issued. Thus, it is very much clear that fetter has been placed upon the mode of recovery in a sense that a person who is liable to pay such dues will not be arrested. However, other modes of recovery can be adopted to as may be considered by the court concerned to be justified. Over.